Hello? Do you watch the news? Okay. I don't know if you do, but the news is extremely graphic and it's devastating. You know, the reason that we do things, we do them for a reason. We don't do them out of spite. We don't do them out of hate. It's so that everyone is protected. That's the reason we do everything. And when we have individuals that pick up certain cases and consecutive in quite a few cases, it draws concern. And at some point, we have to put conditions so that we know that nothing further is going to happen. Because what I don't want is something catastrophic to happen. And that's why we do what we do. It doesn't come out of hate just because I don't like you or I just being hard on him. No, it's just we don't want anything catastrophic to happen. Now, like I said, I'm willing to take the interlock off, but I think for this point in time, this is the measure that we should take so that nothing more drastic happens. Do you understand?
Thank you.
Okay, thanks, ma'am. So, and for future reference, I can waive the signature so they don't have to come in.
Okay.
Just listen to your lawyer. He will take care of you because you have one. I will waive your appearance. You don't have to waste your time coming to court. The only thing, don't consume alcohol. Don't drive unless you have a license and insurance. And just don't pick up any new cases. I'm not asking for much. All right? Okay. Thanks. All right.
So Judge, when the building's being interlocked.
Sure. Yeah. The two others stay on though. Yeah.
And consider also the random ways you do want to.
I think that's good because I want to make sure that there's no illegal drug usage. So random UA should be good.
Well, real quick, we had like a full-blown hearing on that, and he made a decision, and it was based upon reason and logic. There's zero evidence of drug use in this case. And now she's got GPS, she's having an interlock, and she's got a scram, and then she's got a drug test when there's absolutely zero evidence. I mean, Singer was really almost harshly specific on the nonsensical nature of the drug test. And now we're going to do that?
How do I know that there's no drug issue? Am I supposed to take?
How do you know I don't have a drug issue?
Well, I don't care about
I mean,
you. I don't care about you.
I know. I mean,
But I don't care about you.
I don't.
I have someone who's picked up a DWI, then she's picked up another DWI, she's picked up criminal mischief. At some point, it's time to stop going out at night. And I think it's a reasonable restriction.
And you said on the record, at some point it crosses the threshold of being penal in nature, and not practical and actually relevant to the case. And that's what Singer, the other presiding judge who sat here,
What's
said.
relevant?
There's zero allegations of drug use in this case. That's exactly what the judge who filled in for you last week told the state. And now all of a sudden we're adding that now. I mean, I can't keep ahead of the game. The goalpost keeps keeping moving every time I show up here.
I don't know anything about the cases. All I know is that there's two DWIs and a mischief. Normal. So when we get a DWI here, every case is treated the same way. I don't deviate. Every case, it is.
Okay.
Every case is treated the same way. When someone has a DWI, on a first one, I don't put an interlock unless there's some aggravating factor, right? I don't put an interlock. I order random testing. Don't consume alcohol. Don't consume illegal drugs. And you're subjected to random testing. I'm assuming I don't know because I wasn't here for the first one, but I'm assuming that's what happened with the first. Now that someone has picked up a second DWI, what we normally do is we put a scram because I want to make sure that there's no alcohol usage at all. We tried it the first way, the least intrusive manner. Now they've picked up a new case. So the only way that I know that no alcohol will be used is by putting on a scram. Typically, when someone has a DWI also, they're out at night. And when you've got 3 open cases, nothing good happens at 1 or 2 in the morning. The only way that I can monitor someone not going out at nighttime is by putting a GPS monitor. If you have another way, I'm all ears, but I can't take their word for it, not that they're not going to go out. Do you have any kind of allegation of drug usage?
That's what I'm looking at right now, Judge, because the first DWI, she did go to the hospital, so I was trying to see the excess of her at the hospital. She did have a high blood result, so they didn't do tox in our lab, but I'm trying to see the excess of her at the hospital.
What was the blood level?
0.326.
326? 0.4 death?
Well, first of all, it's serum versus whole blood, and you were a defense attorney. There's a big difference.
I get it, but
So again, I mean, here's the thing. Do we need to get a court reporter out here? Because some of the things that you are doing, okay, right now, she has the right to due process and a judge who's fairly considering the allegations in the case, if and only if motions are brought to you. But that reaction that you just did, you're subject to being recused, and I'm this close to doing it with the way that you're behaving.
okay, then if you want to, you can do what you want to do. That's fine. But I think that both of those devices are reasonable in light of everything that has transpired with the 3 cases that are open.
Okay. Is your comment that you just made, I guess, to the public at large here on the stream, I guess you're in, this overreaction to her blood test score on a case that she has not been convicted of, is that reasonable?
Well, my reaction is to your insinuation that I'm being unreasonable.
No.
You're insinuating that I'm being unreasonable.
Like someone had come in here and committed a murder in front of you, the way that you reacted. Do I need to replay the live stream?
Notice what just happened? After pressing the prosecution for evidence, the judge backs away from the random drug testing. That's an important moment. It shows that even during a heated exchange, judges can reconsider a condition when the factual basis isn't there. But the debate isn't over, because the GPS monitor and alcohol monitor stay in place. And that's exactly what keeps this courtroom tension alive.
You can do whatever you want to do. But I'm going to leave the GPS on with the curfew. I'm going to leave the scram on now. Is there any evidence of drug usage?
They don't see, Judge, anything on the talks in regards to the medical records, that it was anything divided. Showing that there was drugs related. I think it was all of them. It is not-
Okay. Then we won't do the random testing. But I think the other ones are reasonable.
Okay. I mean, as an officer of the court and someone who comes into court every week, when you all have visiting judges, particularly one who's been here a long time, longer than both of us in this building, frankly, we have to trust what they do because you put them in trust of these cases and us. So whenever we come into these courts and we trust the process and the judge makes a decision, and then we come back a week later and nothing's changed and the state hasn't filed a motion to change it, okay? There's no additional evidence that's come to light that proves that point. For then the presiding judge to just whimsically say, I'm doing it because I just do it all the time, when a previous judge has already made a ruling. That's not appropriate for anyone who has to come in here and do what we do every single day and every single week. If that's the case, then we don't need visiting judges because they don't, their word, their decisions aren't binding.
You asked me, you came in here today. You asked me to take one of the devices off, and I'm acquiescing to you.
Okay.
Isn't that what has just happened?
Well, as we talked about yesterday when I zoomed in, technically the law requires, because she has a driver's license, because I won her first day law and I'm fighting the other, technically the law requires that she have the intro law. As we talked about yesterday, Article 17.40 does not require a GPS monitor and or a screen. Now, under 1740, you can put a screen on, and I'm not arguing screen, okay? I just think the other one crosses the threshold of reasonableness. But you've already made your ruling on that, and I'm
Which one?
and I'm walking away. I'm not going to fight you on it. But I am going to fight you on when they just simply read something that you have that reaction in front of all these people and my client who has to come back here if we have a trial and trust that you are going to be fair and impartial.
I'm always fair and impartial.
Well, again,
Always.
how do we know
fair
that?
and
People say
impartial.
it, but their actions speak louder than words.
You know, I'm fair and impartial.
No. It's just not feeling like it today with that reaction that you did.
I'm
And if
I'm acquiescing to you.
Defense attorneys that you know and respect in this courtroom, they tell you the same thing.
I'm happy. You can do whatever you want to do. Really.
Okay.
If you want to do, file a motion to recuse, file a motion to recuse.
Okay.
It's fine. But I think in light of everything that we have, as far as the two DBIs and the mischief that both of those devices, I think it's reasonable.
Okay.
Yep.
Well, at this point, I respect your ruling and I ask to just reset the case.
Sure. Hi, are you ready? Please.
I have Mr. Rivas Diaz, final rater.
Do you need a translator?
No, you're.
Okay, come on up, sir. All right, good morning, sir. So
Now
you're
the
charged with
courtroom
driving
shifts
while
to an
intoxicated.
entirely
You're facing
different
up to
defendant.
6 months in
But the
jail
judge's
and or a
philosophy
$2,000
stays
fine.
exactly the same.
We're going
Watch
to do
how quickly the
probable cause. You have the
conversation
right to remain
turns from the
silent.
criminal charge
Anything you say
itself
can
to
and will be
bond
used against you.
conditions designed to
You have the right
prevent
to have an attorney
another
present if you
alleged
cannot afford
offense.
one. One
Whether
will be
you
appointed to
agree or
sir.
disagree, the judge makes one thing
On
crystal
May-
clear.
on May
Repeat
31st,
DWI cases
2026,
are
in
going to
Harris County,
receive
Texas,
aggressive
officer observed the
supervision.
vehicle.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
On May 31st, 2026, in Harris County, Texas, officer observed a vehicle on McKinney Street with a defective license plate and playing extremely loud music. Traffic stop was conducted. An officer made contact with the defendant and observed a strong odor of alcohol separated from the vehicle, bloodshot glossy eyes, and slurred speech. Officer observed an open container was inside the seat pockets on the back of the front passenger seat, which was almost empty and full to the touch. There was also another 32-ounce bottle of Corona that was full to the touch and filled on the floorboard behind the front passenger seat where it was located. Standard field sobriety tests were conducted. 4 out of 6 HGN, 4 out of 8 walk and turn, and 1 out of 4 one-leg stand. TIC was read and the defendant refused to provide a sample of blood search warrant was then executed.
It's damn elementary, Mr. Rivas Diaz, that you're not to have alcohol in the car while you're driving. If it's proven at trial, it's a minimum of 6 days in jail, flat to any sentence that you get. I'm going to find that there's probable cause to go forward with your case. I'm now issuing a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand? You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. You're not allowed to drive unless you have valid liability insurance in your name as well. That is also a condition. You violate these conditions, I will put you in jail. There will be no more PR bonds for you. This is not a revolving door. Do you understand? Okay.
Mr. Leo does not have a valid driver's license. So we're asking for the no driving affidavit and yes, for them.
This is an affidavit that you're going to sign with me, Mr. Rivas. If I find that you drive, I can have a contempt hearing every time you drive. It's a violation in and of itself, and I could throw your ass in with 180 days every single time. Do you understand? There's nothing in this life that you can justify getting into a car and driving. I will put you over my knee like a little child, and it's not gonna fare well for you. Do you understand? You act like a child, you will be treated like a child. So what was he driving then?
He was driving a vehicle, Your Honor, but he is present with his mom. Which I believe.
He's still gonna have to put an interlock on it because I don't trust that he's not gonna drive without it. You will also get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You do, and I don't care what the excuse is. It's just not gonna go well for you. You understand? Okay, come on. Thank you. Yes, ma'am. Hi. Yes, ma'am.
Yeah, Mr. Watson, this was the drift points. and
Sure, I remember.
I think this way probably have more information on what's going on with this.
Do we have TRAS done in this case? What did they suggest?
So they were very much focused on his felonies and they didn't really make a commentary on requests for these cases. It's
What?
like, there was classes and stuff regarding like the charge upstairs.
Yeah, but they would have, did they get on Watson? They get a TRAS. We did a TRAS.
Yeah, I think they
If
put
you don't mind.
a moderate risk.
I can find out, what was the first name?
Trevin. But I mean, basically the entirety of it, well, the recommendations at least for regarding the felony case.
It was what?
I think they recommended
Is that it?
IFS, maybe some classes. I think I got it on paper, I don't have it.
I'm gonna get it, don't worry.
But Mr. Watson, it
Yes, ma'am.
was recommended, I want to look for it. It was
Yeah.
recommended on the condo.
Great, I think that's,
Domestic violence,
Yep.
case law and this.
can I do ISF cognitive?
It was recommended for if it was needed.
I think that's a good idea.
I'm unaware of what ISF entails.
It's basically, it's an in-treatment. It's an inpatient treatment program, essentially is what it amounts to.
Inpatient treatment for what?
Um,
And cognitive behavioral issues to kind of teach you how to,
The cognitive behavior.
right.
The student ones.
So you were asking how things should go. What I normally like to do is follow what TRAS recommendations are. If not, you can just set up a trial. But, you know, considering,
So you would not accept a plea
I would,
out of the ISF?
right, essentially. Because he's got 4 cases, he's got bond violation after bond violation after bond
I know,
violation.
Judge, which is why that we're here, we were supposed to have a hearing with Sentinel Tech about these stricter ones.
He's still in custody, he's on bond. I haven't put him in jail.
I know.
So I'm giving you the benefit of the doubt on that right now as we speak. But at some point, these cases have to finish up. We can't just keep them open forever.
I know, Judge, I know. And like I've repeatedly said, when we.
Our theft case is 250 days old.
And he's been willing to plead on that case for months.
So this is it. But
This is one of those moments that people watching online instantly debate. The judge isn't just looking at today's charge. He's looking at the defendant's entire history while on bond. Legally, prior pending cases can influence bond decisions, but comments about appearance or lifestyle often become controversial because viewers question whether they're relevant or simply frustration boiling over. What do you think? Should judges stick strictly to the legal facts, or is context part of the job?
you know, when I have people on the docket who have many issues, I don't know how to go forward. Come up. Around this way. Here comes Mr. Watson, who's made a $100,000 bond, who we've given an appointed lawyer to, who has 1, 2, 3, 4, 5, 6, 7, 8, 9, another 4, and homeboy's got on a Gucci belt. It's probably like $600.
I know, Judge, I know.
Mr. Watson.
Talking about the Gucci belt, they're playing of fake Gucci belts, but I understand.
Mr. Watson,
Sir, no, sir.
let me give you some perspective. These cases need to be done. And I will give you to the end of this week to figure out what you want to do. But I have evaluations done for a reason, because
Sir, that's concerning my felony charge, not concerning my bill charge. And one of my theft charges, they have evidence that I did not do. And I don't know why it's not being presented that the evidence that I did do. So the only thing that I really done it up is the original.
stop. You have the right to remain silent. Don't say anything, because whatever you say now, they're going to use it to prove your guilt. Just listen.
I'm admitting to the original charge.
Stop. Listen. While you have been on bond for your first theft case here, you've picked up another 3 cases. While you have been on bond for these cases, you have had a multitude of bond violations. I don't know how to go forward, but the only thing I know, stop. I want you to listen, because while you're trying to think of what to say, you're not listening what I'm trying to tell you to impart to you. I am trying to figure out the best way to go forward, and I don't know. All I know are 2 things. Number 1, I want to protect my community. And number 2, you've picked up a boatload of cases within the last couple of years. So what we do is have you evaluated to see how best going forward. And what they recommended is ISF, which is an intersanctional facility with a cognitive treatment. Okay? That is what they are recommending. I am not an expert. I don't know. That's why we have clinicians on staff to tell us how to go forward when we have those who continue with.
Other than the ISL sprung from my felony charge. It wasn't just, that's.
You, look, I, as a judge here, am within my right to accept a plea bargain or to reject. Okay? That is the job that we have here, in addition to try to protecting our community. Why we have people on staff is try to help us with a little guidance on how to go forward, so this stops before it becomes a 50-year sentence.
We never get to that because my cases are so, they have the deadlines that
I'm prepared now.
Recommendations other than ISF, sir.
If you don't have to do anything, but then what we will do is we will set your cases for trial,
Go to trial.
and we will go to trial on all the cases. And if you're found not guilty, then you're found not
I
guilty.
know I'm dead to the wrong, Judge. Why
So-
would I take this case to trial when I have a case that's
Stop.
already being dismissed? I'm kidding. Judge, you know this doesn't make any sense. I have a weed case and a third case that I'm admitting to. I know I have a right to remain.
Man, get your boy.
I know, Judge, I know.
I am giving you,
It's time to think about if I'm gonna go to trial or if I'm gonna go to ISF. That's my.
You said by the end of this week, Judge? Okay, you want anything?
well, you guys go over all the evidence, decide what you want to do, but I'm giving you a heads up on what I think is appropriate, considering all this that we have in front of us.
I still have a felony case to get.
Great. And the idea is to work out some kind of global resolution. But your case is 250 days, and you're now on your umpteenth bond violation. Stop. I'm not putting you in jail now, but I'm putting the stop now because I'm tired of the violations.
Violation obviously is wrong if they're jury points. I didn't violate anything.
Great.
The technician.
That's why you are in the free world now and not in jail with a $100,000 bond. I'm not going to argue with you. I'm telling you how it is. I'm going to hold your ass in contempt. Go. Now I'm revoking your bond. Go.
I will say,
Nope. Go.
You just told me you was gonna give me, I'm trying to talk to you, Judge.
Sure. Go.
Just go here.
I just want to say we did, reach out to Sentinel, and
It's over. It's over. I don't care. I'm just ready to put this, it's done. I'm ready to put this baby to bed. So he either, that's it.
How long is, ISF?
I have no idea. It depends on them.
It's 45 days, depending on the progress, and I'm like 120 days.
Okay. Are you taking him into custody, Judge?
Totally.
I'll go talk to him.
Okay.
Okay, I'm just trying to figure out what's going on right now. Are you revoking his bond?
I'm revoking his bond. I'm not going to hold him in contempt. I'm going to revoke his bond.
Okay, can we set a bond?
Yeah. And I'm going to double all of them except for the felony case. But so now 50,006, please, on all of his cases. And then, but talk with him this week. We need to decide whether he wants to set him for trial or whether he wants to accept it. But
I think he's just frustrated because when we were on here on Friday, it seemed to be about the Sunday Cup and it was about the hearing. And now that we're here, all that is just being thrown out in the dust. He
I was-
care about Sunday.
no, it's just way too much drama. And I'm just ready to put it to bed. It's just going to continue. It's every week we have a new bond violation. If it's this, if it's that, let's just be done with it once and for all. The theft is 250 day, or one of the cases is 250. It's time. So,
We'll talk to this,
also the only other thing I would say is, do you know who the felony lawyer is? So maybe,
I mean, he's not taking on the felony, you know that.
okay, so we'll just do, I don't know if there was a global resolution
There
that's,
probably is, but he's not. I mean, the multiple times I've talked to him, he's not taking their TBC off.
oh, they offered him